5, review 100 questions. A lender is placing a $400,000 loan. The borrower will not be charged an origination fee on the first $50,000, but will pay $4.20 for each $1,000 of loan amount over $50,000. The origination fee will be alpha $1,470. So origination fee. So you need to do some math on this one. Tenant vacates a property having done $1,250 worth of damage. The tenant also left an Xbox valued of $250 in the property. The tenant contacts the property manager within 10 days and demands a return of the Xbox and a $1,000 security deposit. The manager must return the Xbox, but may keep the $1,000 security deposit. So security deposits are fully refundable, but if the tenant does damage, you can keep that security deposit. But personal property, you got to return it. So that tenant demanding this Xbox, give him back his Xbox, any personal property. But his security deposit, if he does damage, you can use that security deposit for that damage. So B, must return the Xbox and the $1,000? No. May keep the Xbox but return $1,000? No. May keep the Xbox and the $1,000? No. A buyer pays $175,000 for an office building with $25,000 as a down payment. Over 6 years, the buyers pay $12,000 on the mortgage, of which 50% is interest. Disregarding interest, what percentage of the purchase price has the buyer paid? 18%. So again, this one's going to require a little bit of math behind the scenes. So what percentage of the purchase price has the buyer paid? 18%. If an attorney refers clients to a real estate agent and in return receives referral fees, the attorney alpha must be a licensed real estate agent. Must be a licensed real estate agent. So if an attorney refers clients to a real estate agent and in return receives referral fees, that attorney must be licensed, right? So, and anytime anybody's going to get paid based off real estate and it's a fee, do they need to have a license? Yes, right? They need to have a real estate license to get paid from real estate, period. Has violated duty of confidentiality to the client? No. Must get permission from the Bar Association? No. Has violated provisions of RESPA? No. When a temporary broker's license is issued, the broker may not initiate new business. So when a temporary broker's license is issued, the broker may not initiate new business. So when a temporary broker's license is issued, the broker may not initiate new business. Hire licensees, they can do that. Sever licensees, they can do that. Pay referral fees, they can do that. But when you get a temporary broker's license, you can't have new business because temporary is because something else happened. Which of the following statements is true? It is alpha. A buyer's agent may offer unlicensed buyer clients a premium, such as a big screen TV, if they purchase a home. It's kind of like taking a commission reduction, but you're just substituting for, your commission, and you're buying them a TV. That's okay. So again, a buyer's agent may offer unlicensed buyer clients a premium, right? So if you tell your client, hey, I'll offer you a premium, I'll throw in a big screen TV, if you choose me as your realtor, that's okay. To encourage sellers to list with them, a licensee may give potential sellers an opportunity to win a cruise in an annual drawing. No, it's not allowed. A broker may give an Amazon gift card to unlicensed former clients who refer friends to the broker. Again, unlicensed is the key word here. You can't give them Amazon card or any type of gift card to unlicensed people. A subdivision developer may conduct a lottery to solicit potential buyers without obtaining permission from ADRE. So that is not true. Subdivision developer may conduct a lottery. So again, a lottery, right? That's the main problem here. A lease in which the landlord pays the utilities and property taxes is most likely a gross lease, right? A lease in which the landlord pays the utilities and property taxes is most likely a gross lease, right? It's not a net lease, it's a gross lease because there's picking and choosing of things here, right? Utilities and property taxes, it's gross lease. Those are itemized items. Is it a net lease? No. Percentage lease? No. Index lease? No. Which is exempt from a public report? It is alpha. Resale of a subdivided, unimproved lot by a private party to another party. That's exempt from a public report. Exempt from a public report. So resale of a subdivided, unimproved lot by a private party to another party, that is exempt from a public report. Resale of one lot after a builder purchased 100 lots in a bulk sale, that's not exempt. Resale of 6 1-acre lots resulting from a 24-acre parcel that was originally split into 4 lots, that's exempt. Resale of 12 timeshares in the same apartment, same development, that's exempt. I'm sorry, those are not exempt. A is exempt. Resale, subdivided, unimproved lot by a private party to another party. If a property for sale is located near a municipal airport, the listing agent must provide a disclosure of the location of the airport. So if a property for sale is located near a municipal airport, the listing agent must provide a disclosure of the location of the airport. So, I mean, this goes again, if it's near a military airport or some sort of municipal airport, you have to disclose the location of the airport on the listing, right? So the listing agent must provide a disclosure of the location of that airport. How about an abatement report? No. Noise decibel reading, both inside and outside of the house? No. Report on the types of aircraft at the airport? No. Which article of Arizona Constitution created state trust land? This is going to be Alpha 10. So Article 10 of Arizona Constitution created a state trust land. Article 10. Article 26, sometimes people get confused. Article 26 gives, powers for real estate agents to write contracts. 32, no. 44, no. The Aranki versus RKP Realty case is important because it clearly shows that alpha licensees may be liable for false statements made in good faith. Licensees may be liable for false statements made in good faith. Licensees may be liable for false statements made in good faith. So an affidavit of disclosure will suffice as full disclosure by licensee. No, that's not what the case was about. Concept of caveat emptor provides licenses and means of avoiding liability. No. Square footage of a property is not relevant to the transaction. No. A buyer makes an offer on a property on which the seller has already accepted an offer. If the seller accepts this new offer, it should contain a contingency clause. Contingency clause. So again, a buyer makes an offer on a property on which the seller has already accepted an offer. If the seller accepts this new offer, it should contain a contingency clause. So you can, push out 3-4 offers, and say the seller accepts that offer. They can accept 2 or 3 offers, 4 offers, 5 offers. Only the first offer is under contract, but all the other ones are contingent based on the first offer, right? So, say you get an offer on a property, so you're the seller, you get 10 offers, you can accept all 10. But the first one is only one that goes under contract. The other 9 needs to have contingency clauses saying that it's not under contract unless that first one that was accepted goes under, doesn't close, right? So, should it contain a release clause? No. A subordination clause? No. A hold harmless clause? No. It should contain a contingency clause. In the Barnes versus Lopez case, it is Alpha advertising the property as business zoned when only a portion of the property was business zoned was deemed to be a misrepresentation. Misrepresentation. So in the Barnes versus Lopez case, advertising the property as business zoned when only a portion of the property was business zoned was deemed to be a misrepresentation. Right? So in the Barnes versus Lopez case, again, advertising the property as business zone when only a portion of the property was business zone was deemed to be a misrepresentation. The agent was found not liable for advertising the property. No. It was decided that placing a sign on a property is not considered advertising. No. The court held the agent harmless because the seller had misrepresented the property to the buyer. No. All the following are associated with non-judicial foreclosure of a trust deed except Alpha right of redemption. All the following are associated with a non-judicial foreclosure of a trust deed except right of redemption. So is it right of reinstatement? Yeah. Beneficiary? Yeah. Recorded notice of sale? Yeah. So those are all associated with non-judicial foreclosure except the right of redemption. A purchase agreement uses a standard clause that states this contract cannot be altered, amended, changed, modified, revised, or terminated without written specific consent of both the buyer and seller. To make a change to this purchase agreement, Alpha, the buyer and seller, can communicate the changes via email. The buyer and seller can communicate the changes via email. So again, a purchase agreement uses a standard clause that states this contract cannot be altered, amended, changed, modified, revised, or terminated without written specific consent of both the buyer and seller. To make a change to this purchase contract agreement, the buyer and seller can communicate the changes via email. How about the buyer and seller can agree to the changes over the phone? No. When it's over email, it's in writing. One party can make the amendment in writing. No, it needs to be at both parties, so buyer and seller. Fast mail transmission of the amendment from one party is acceptable. No. A licensee would not be violating Arizona law in which situation? It is alpha preparing documents in a real estate transaction when the licensee represents only one party. A licensee would not be violating Arizona law in which situation? So when they're preparing documents in a real estate transaction, when the licensee represents only one party. So preparing documents in a real estate transaction when the licensee represents only one party. That's not violating the law. B, acting as a facilitator in transaction and charging a document prep fee. So you can't charge the fee, so that's no. Writing a purchase contract for a buyer and a seller on a for sale by owner property for a fee, no. Acting as a dual agent when informed consent has not been granted, no. A substance known to be hazardous because it is friable fibers of its friable fibers known as asbestos. So asbestos is hazardous, right? Shouldn't we bring that in as friable fibers? And that's called asbestos. Is it formaldehyde? No. Polybutene? No. Lead paint? No. Which of the following bankruptcy chapters allows for liquidation of a debtor's assets? It's Chapter 7. Chapter 7. So which of the following bankruptcy chapters allow for liquidation? So selling your assets. Chapter 7. So if you think about it, you got 7, 10, 11. So 7, 10, 11, 13, no. But the first one, chapter 7, is sell, right? So you can think of the first one, chapter 7, that allows you to sell your assets to satisfy the debt. An active management area is an area in which excessive overdraft is occurring. Excessive overdraft is occurring. As an active management area, AMA. Excessive overdraft. So think of it's very active, you're overdrafting quite a bit, so excessive overdraft is occurring. Excessive irrigation, no. Surface water, no. No new wells can be drilled, no. A parcel of land that benefits from an easement is known as the alpha dominant estate. So you got the dominant estate, you got the servient estate. The dominant estate always benefits. That's the beneficiary, right? That's the benefit one from an easement. The dominant state always benefits. The servient state is the one getting stepped on. So that's, you got the dominant state, you got the servient state from an easement. So is it servient state? No. Opportunity state? No. Engrossed state? No. After a trustee's sale under a deed of trust, how long does a trustor have to redeem the property? This is alpha, 0 days. 0 days. After a trustee's sale, you got the trustor, you got trustee, mortgagor, mortgagee. After a trustee sale under a deed of trust, how long does a trustor have to redeem the property? So you got 0 days. 9 days? No. 6 months? No. 3 years? When a broker has earned a commission, but the seller refuses to pay for no apparent reason, which of the following statements would be incorrect? Alpha, the broker may place a commission lien on the property in order to postpone the property transfer. So this is incorrect, right? You can't do that. So broker, they have to allow the transaction to close. They can't put a lien on the property in order to postpone the property transfer. The broker may sue the seller after the close of escrow. Yeah, you can sue them after. The broker may not let a commission dispute interfere with closing of a transaction. Yes, right. That's the main thing here. You don't let any disputes. Don't let the disputes interfere with closing a transaction. Broker may later obtain an attachment on the seller's personal assets if a judgment is obtained. That's true. Broker may later obtain an attachment on the seller's personal assets if a judgment is obtained. Who may legally manage a single office building for a fee? Alpha, natural person who is an employee of the property owner, right? So a natural person who is an employee of the property owner. So who may legally manage a single office building for a fee? So if you wanted to manage an office for a fee, that would be a natural person who's an employee of the property owner. A corporation whose shareholders are related to the owner? No. LLC that has members who are real estate brokers? No. Partnership formed by 3 real estate salespersons? No. Which of the following statements relating to a broker's temporary absence and appointment of a licensee during the absence is correct? Alpha, the appointment of a salesperson in the company may not be for longer than 30 days. Right? The appointment of a salesperson in the company may not be for longer than 30 days. So which of the following statements relating to a broker's temporary absence and appointment of a licensee during the absence is correct? The appointment of a salesperson in the company may not be for longer than 30 days. So that's true. B says the appointment of another designated broker may be for more than 30 days. No, right? It can't be longer than 30 days. A notice of the appointment of another licensee must be sent to ADRE. No. The company's designated broker may not be absent for more than 24 hours. No. When a salesperson who has a written employment contract with his broker places a contract in escrow and then leaves the employment of that broker, what is the status of the salesperson's commission? It is alpha. The salesperson would receive the commission since he placed the contract in escrow and would be paid by the former broker. So the salesperson would receive the commission since he placed the contract in escrow and would be paid by the former broker. Right. So if you're out there doing deals and you get the deal all the way to title, you are to be paid. Right. So when a salesperson who has a written employment contract with his broker places a contract in escrow and then leaves the employment of that broker, what is the status of the salesperson? What is the status of the salesperson's commission? The salesperson will receive the commission since he placed the contract in escrow and would be paid by the former broker. B, the salesperson could not receive any commission since he was no longer working for that broker at the time of closing. No. The salesperson would receive whatever the broker felt was equitable. No. The salesperson would be obligated to split whatever commission he received with his new broker. No. In the Lombardo versus Albu case, the court held that alpha, the duty of disclosure. All right, which of the following is not community property? Alpha, a gift of land made only to the husband. That would not be community property. A gift of land made only to the husband. So a gift of land made only to the husband. That's not community property. How about salaries of the husband or wife? So husband owns, makes a salary, this wife, right? It's the wife's. If the wife makes salary, it's the husband's, right? Once you're married, husband and wife salaries are together. That's community. A house purchased by the husband and wife, that's community property. Commercial property devised to the husband and wife, that's community property. But if the husband got a gift and it was only to the husband, is that community property? No, that is not community property. The main issue in the Development Corporation versus Pima Capital Management case was Alpha, failure to disclose the presence of polybutylene plumbing. Failure to disclose the presence of polybutylene plumbing. Failure to disclose the presence of polybutylene plumbing. So that's the main issue in the Development Corporation versus Pima Capital Management case, was the failure to disclose the presence of polybutylene plumbing. Was it the buyer's inability to qualify for a loan? No. Misrepresentation of a buyer of a property square footage? No. Failure of a seller to disclose termite damage? No. The monthly income on one unit in a duplex is $325, and the other unit rents for $350. Rent is collected on the first of each month. The duplex sells and closes on September 23rd. What is the prorated income the buyer receives? So go to the section 9 from pure math calculations. Piece of property sells for $125 an acre, and the sales price is $185,000. What's the size of the property? 1480 acres. Long-term capital gain treatment applies if the property has been held for more than 12 months. Right? So any property you hold longer than 12 months, that's long-term capital gain. If it's less than 12 months, short-term capital gain. So the delta, the differential here is bigger than 12 months, long-term capital gain, less than 12 months, short-term capital gain. So long-term capital gain treatment applies if the property has been held in more than 6 months, no. 18, 24, no. A two-story building measures 24 feet by 30 feet and has 8-foot ceilings. What's the square footage of the building? Bravo, 1440. A property sells for $55,000 with a 6% commission paid to the broker. The salesperson gets paid based on a 2-to-3 ratio split, with the salesperson receiving the higher portion of the ratio. The salesperson's share would be $19.80. A home sells for $405,000 but was listed for $435,000, and the buyers are getting a 90% loan. The sellers are paying a 6%, and the buyers want the sellers to pay 2 discount points. The sellers are paying for a $55 recording fee, $17.35 in closing costs, and $253 for title insurance. The sellers originally purchased their home for $250,000, and their loan balance is $183,000. What are the seller's proceeds from the sale? So this one's going to be $188,000. A listing agent and a seller have a dispute over a commission during the close of escrow, and the seller refuses to pay. What actions can the listing agent take? Bravo, they can take civil action against the seller after closing. And the key word here is after closing. Can they do anything before closing? No, you have to allow the transaction to close. So take civil action after the seller, against the seller after closing. So take civil action against the seller after closing. Take civil action against the seller after closing. Can they file a commission lien against the seller? No. Can they stop the close of escrow on the property? Definitely no. Renegotiate the commission rate? No. A clause that allows a lender to take over collection of rents when a borrower is in default is a bravo assignment of rents clause. Assignment of rents clause. So this is a clause that allows a lender to take over collection of rents when a borrower is in default. It's called an assignment of rents clause. The lender is assigning someone else to take over the rents when the borrower is in default. It's called an assignment of rents clause. Is it a cross-collateralization clause? No. Subordination clause? No. Non-recourse clause? No. Which of the following protects the lender in the event of a foreclosure? So this one's going to be bravo. Mortgage insurance. Mortgage insurance. So which of the following protects the lender in the event of a foreclosure? Mortgage insurance. So a lot of companies or loans will get PMI, private mortgage insurance, PMI. That's private mortgage insurance, right? Mortgage insurance protects the lender. Mortgage insurance makes sure that the lender doesn't get, makes sure that the lender is protected against if there's a foreclosure in case of a default, right? So is it title insurance? No. Homeowners insurance? No. Mortgage life insurance? No. It's mortgage insurance. Mortgage insurance protects the lender in the event of a foreclosure. Arizona brokers have liability for out-of-state salespersons if they enter into a cooperation agreement. So Arizona brokers have liability for out-of-state salespersons if they enter into a cooperation agreement. Arizona brokers have liability for out-of-state salesperson if they enter into a cooperation agreement. Arizona brokers are required to cooperate with out-of-state? No. Are not responsible for action their in-state licensees? No. May not maintain a non-resident Arizona license? No. So, if you have any questions, call up your broker, ask them. When there is a discrepancy between the pre-printed words and written words in a purchase contract, which of the following statements is true? Bravo, the written word prevails. The written word prevails. The written word prevails. So when there's a discrepancy between the pre-printed words and written words in a purchase contract, which of the following statements is true? The written. So is it so which one prevails? Pre-printed or the written? The written word prevails. So I know a lot of sales contracts are boilerplated, meaning that we have standard boilerplated purchase contracts. But if you write something in that contract, that written word is going to always win. All right, that written word, what you wrote down, will prevail over any boilerplate, any pre-printed words that was already on there. Right, the pre-printed words is not going to supersede anything that's written already. If you write something that's going to supersede, that'll supersede it. So the pre-printed word prevails? No. Pre-printed contracts cannot be changed? No. The contract is unenforceable? No. Ratio of net income available from a commercial property to service the mortgage payments is Bravo, debt coverage ratio. Debt coverage ratio. Debt coverage ratio. So the ratio of net income available from a commercial property to service the mortgage payments is the debt coverage ratio. Debt coverage ratio. That's the ratio of net income available from a commercial property to service the mortgage payment is the debt coverage ratio. Is it the consumer price ratio? No. The market analysis ratio? No. The capitalization ratio? No. In which case would a real estate company not be able to continue business indefinitely? Bravo, death of a designated broker who was the sole shareholder of the licensed corporation. So if your DB dies, right, and they're the shareholder of the license, and they're the main sole shareholder of the licensed corporation, that would, in which case would a real estate company not be able to continue business indefinitely? So B, death of a designated broker who was the sole owner shareholder of the licensed corporation. So say your DB dies and they're the only shareholder and you're the salesperson, a real estate company would not be able to continue business because your DB died, right? You have to be under a broker. Say your broker dies, then you got to go to another brokerage. Death of a licensed salesperson who was with the company for 30 years. No. So if you're, all your salesperson people die, can the company still go on? Yeah, right. The designated broker is the person that typically has shareholder of your licensed corporation. Death of an unlicensed member of the brokerage entity. No, your company can still go on. Death of an associate broker who owns shares in a competing brokerage company. No. So, I mean, one, it's your DB died, right? You don't have a broker, and they had a main shareholder. An option contract allowing the optionee to purchase or lease other properties at some future time is a Bravo rolling option. So rolling option is an option contract allowing the optionee to purchase or lease other properties at some future time. Called a rolling option. Is it a lease option? No. Memorandum of option? No. Option with right of first refusal? No. If a salesperson enters into a buyer-broker agreement with the buyer, right? A salesperson enters into a buyer-broker agreement with the buyer. What happens? It is Bravo. The agreement must be entered into the company transaction log. Right? So if a salesperson enters into a buyer-broker agreement with a buyer, the agreement must be entered into the company transaction log. The agreement must be entered into the company transaction log. So if a salesperson enters into a buyer-broker agreement with a buyer, you got to enter it into the company transaction log. So with any purchase contracts, you always enter it into the company transaction log, right? It needs to be chronological, and it's always open for the commissioner to review. 5-year permanent file need not be opened. No, if you close it, you need to hold it for 5 years. If it's rejected offers, 1 year. It needs to only be signed by the buyer to be enforceable. No. It has to be signed by both parties. No commission would be owed because buyer-broker agreements are unenforceable. No. A monthly performance bonus may be paid to an Bravo, on-site residential property manager. A monthly performance bonus may be paid to an on-site residential property manager. Monthly performance bonus may be paid to an on-site residential property manager. Unlicensed assistant who generated over 20 leads? No. Unlicensed tenant in an apartment complex for referring friends? No. Telemarketer who gave callers information about property values? No. In advertising real estate, Bravo, an inactive licensee who markets her own house for sale must include the words owner, agent. Owner, agent in any ad. So in advertising real estate, an inactive licensee who markets her own house for sale must include the words owner, agent in any ad. So the key word here is inactive, or it could be active. But a lot of people get this wrong because it says inactive licensee. It doesn't matter if they're inactive or inactive. It matters that they have a real estate license, right? So if you're inactive, you still need the words owner, agent in any ad, in any advertisement you do. Facebook advertisements, purchase contracts, whatever. You need to have owner, agent. The designated broker must supervise all ads with no exceptions. No, the term acre could apply to either full acre or commercial acre. No, the commercial rules do not apply to commercial property for lease. No. If a man buys a property, closes escrow, but dies before the deed is recorded, Bravo, the property goes through probate, right? The property goes through probate, right? So he closed escrow, it just wasn't recorded, so it's still going to go through probate, meaning it's going to go to his heirs. Transaction is canceled? No, because closed escrow. Property passes automatically to the man's heirs without probate? No. Property passes to the state through a sheet? No. In the case of Verma versus Stir, the court decided that failure of the seller to give the buyer an affidavit of disclosure, Bravo, allows the buyer to cancel the purchase prior to closing. Allows the buyer to cancel the purchase prior to closing. Allows the buyer to cancel the purchase prior to closing. So this is in the case of Verma versus Stir. The court decided to failure of the seller to give the buyer an affidavit of disclosure allows the buyer to cancel the purchase. So buyers, the buyers always have a lot of ability to cancel the deal, depending on a lot of things, right? So here in the case, the buyer cancels prior to closing. Yeah. Allows the buyer to cancel the purchase for up to 7 days after the transaction closes. No, after it closes, right? You don't have a right of rescission period here. Is not required if the property is 160 acres or more. No, is required only if the property is completely outside of a city or subdivision. No. A site plan, right? A site plan includes all of the following except what? A site plan includes all the following except, Bravo, a building envelope. A building envelope. So a site plan includes all the following except a building envelope. Does a site plan include a building footprint? Yes. Utility easements and lines? Yeah. Parking and landscaping? Yeah. Does it include a building envelope? Not really. In order to obtain a prescriptive easement, there must be, bravo, adverse use. Adverse use. Adverse use. In order to obtain a prescriptive easement, there must be adverse use. So permission from the owner, no. Interrupted use, no. Dominant and servient owners, no. So in order to get a prescriptive easement, there must be adverse use. Which of the following is required under the Real Estate Settlement and Procedures Act? Bravo, the borrower has the right to inspect the CFPB closing disclosure 3 business days before closing. The borrower has the right to inspect the CFPB closing disclosure 3 business days before closing. So which of the following is required under the Real Estate and Settlement and Procedures Act? The borrower has the right to inspect the CFPB closing disclosure 3 business days before closing. Disclosure of finance charges as an annual percentage rate, no. 3-day right to rescind a refinance plan, no. The ability to have errors in credit reports corrected, no. If an offer is rejected but eventually results in a binding contract, the records must be kept for, bravo, 5 years from closing or termination of the contract. 5 years from closing or termination of the contract. So if an offer is rejected but eventually results in a binding contract, the records. So I mean, think about it. If it's rejected offers need to be kept for 1 year. But this one actually materialized, so you need to keep it for 5 years, right? 1 year from the date of rejection, no. 1 year from the contract date, no. 5 years from the date of rejection, no. Which of the following advertising situations violates Arizona Commissioner's rules? Bravo, a broker excludes the company name but includes the company phone number. So what do we know about advertising? You always have to have the company name prominently. So that's a big violation, big violation of the commissioner's rules. Right? If you don't have your company name, that's the number one thing you need on ads, on every single advertisement you do. A licensee lists a brokerage firm in a Facebook post, that's fine. The broker's website shows the company logo more prominently than the company name, that's fine. A broker advertises a property she owns and includes the term owner agent, that's fine. An unlicensed officer of a real estate brokerage licensed as a corporation, bravo, may manage company-owned real estate but may not receive extra compensation. May manage company-owned real estate but may not receive extra compensation. So this is with an unlicensed officer, right? So they don't have a license, not a real estate license. They may receive additional compensation for helping to sell corporate-owned property. Yes. Is subject to disciplinary action by the ADRE for violating Commissioner's rule. Yes. Has no right to make a claim against the Real Estate Recovery Fund. Yes. Only people that have the right to make a claim is licensed agents. Bravo, may manage company-owned real estate but may not receive extra compensation. In a purchase contract, a buyer has 45 days to conduct environmental research on a property. This is referred to as Bravo due diligence. Due diligence. So in a purchase contract, a buyer has 45 days to conduct environmental research on a property. This is referred to as due diligence, right? Due diligence is where you're going to do your home has 45 days to conduct environmental research on a property. This is referred to as due diligence. The Hill versus Jones case. The Hill versus Jones case. Bravo found that the first sale by owner sellers are liable for failing to disclose defects. Found that the FSBO sellers are liable for failing to disclose defects. Hill versus Jones case found that the first sale by owner sellers are liable for failing to disclose defects. So you always got to disclose defects, material defects. Relieved for sale by owner sellers on the duty to disclose. No. Found FSBO sellers liable to pay commissions. No. Exempts FSBO sellers from paying any compensation of brokers. No. A loan provision that makes different properties, real or personal, collateral for the same loan is a Bravo cross-collateralization loan. Cross-collateralization loan. Cross-collateralization loan. So a loan provision that makes different properties, real or personal, collateral for the same loan is cross-collateralization clause. So that's the provision. Is it a blanket loan? No. Carve-out clause? No. Mezzanine clause? No. Broker G was paid a commission at the close of a sale of an apartment complex. Broker G demanded more money for drawing leases, which were incidental to the sale. How much more can Broker G receive? Bravo, nothing, because he can't charge for drawing leases in Arizona. So you can't charge money for drawing up a lease, right? So you can't get anything more, nothing, right? So nothing because you can't charge for drawing leases in Arizona. So Broker G was paid a commission at the close of a sale of an apartment complex. Broker G demanded more money for drawing leases, which were incidental to the sale. How much more can Broker G receive? Nothing, right? Because you can't charge to draw up a lease. Full commission, no. Amount permitted in the landlord and tenant act, no. An amount that is agreed upon between the broker and the client, no. A judgment is entered against a debtor who owns 3 properties. The judgment is a lien against Charlie, all 3 properties. Judgment is entered against a debtor who owns 3 properties. The judgment is a lien against all 3 properties. So, if the owner is against, if he owns 10 properties, judgment's going to be against all 10 properties, or 3 properties, or however many properties they have. Alpha, the property first acquired, no. The property last acquired, no. Homestead property only, no. A document recorded to give notice of an optionee's rights and usually does not include the terms of the option is a Charlie memorandum of option. Memorandum of option. So memorandum of option is a document recorded to give notice of an optionee's rights and usually does not include the terms of the option. Right? Does not, a keyword here, does not include the terms of the option. It's going to be a memorandum of option. Is it a rolling option? No. Lease option? No. Right of first refusal? No. Which of the following dimensions contains the largest area? Charlie, 2 miles square. So 10% of township, no. 2 sections, no. 1,400 acres, no. 2 miles squared, yes. 2 miles squared. Which of the following metrics contains the largest area? 2 miles squared. An estoppel certificate is normally used when a loan is assigned. Loan is assigned. Loan is assigned. That's when you're going to use an estoppel certificate. When you have a loan that's been assigned, an estoppel certificate, that's when it's going to be used. When a loan must be stopped, no. Property sold, no. Loan is assumed, no. Loan is assigned. Which of the following statements is correct? In relation to an exclusive right to sale listing. Which of the following statements is correct in relation to an exclusive right to sale listing? It's going to be Charlie. Either party has the right to terminate employment agreement, but there may be consequences. So either party has the right to terminate an employment agreement, but there may be consequences. So A, the seller cannot cancel the listing prior to the expiration date. No. The broker cannot abandon the listing without just cause. No. No expiration date is required. No. A designated broker may not pay Charlie a team that is formed as an LLC. A designated broker may not pay a team that is formed as an LLC. A team that is formed as an LLC. So a DB of designated broker, they only pay the agents, right? The realtors. But they may not pay a team that is formed as an LLC. Associate brokers who are a PLLC, yeah, they can pay them. Salespersons who are a PC, that's okay, you can pay them. Unlicensed persons who do telemarketing, you can pay them. A team that's formed as an LLC, no. The case is Kelo versus New London and Bailey versus City of Mesa dealt with Charlie, eminent domain. Eminent domain. Again, the case is Kelo versus New London and Bailey versus City of Mesa dealt with eminent domain. So was it taxation? No. Police power? No. SG? No. The central air conditioning unit breaks down in an apartment building during a heat wave. According to the Residential Landlord-Tenant Act, the tenants may immediately give the landlord a 5-day notice to repair it. Give the landlord a 5-day notice to repair it. So, say this happened to me. I was renting. I had tenants renting out my house. So they needed AC went out. They told me right away. Next day I was on it, repaired it next day. But I have 5 days to repair it. Can they rent window or air conditioners and deduct the cost from their rent? No. Refuse to pay rent until the unit is repaired? No. Abandon the premises immediately? No. A loan of $28,000 is made at 10% interest for 15 months. What's the total amount owed when the loan is due? Okay, and you do some math. No. A property in a 90-unit planned unit development is being sold. All the following items must be disclosed to the buyer except what? Charlie, a copy of the Homeowners Association insurance policy for the common areas. So HOA assessment charges due from the selling member, yeah. The amount of money held by the association as reserves, yes. The operating budget for the current fiscal year, yes. So a property in a 90-unit planned unit development is being sold. All the following items must be disclosed to the buyer except a copy of the homeowner association insurance policy, the common areas, which is the first step in the foreclosure of a tax lien. Notice is sent to the property owner. Notice is sent to the property owner. Notice sent to the property owner. So, first step in the foreclosure of a tax lien. Notice sent to the property owner. Notice sent to the mortgagee. No. All parties must be notified. No. Treasurer must be notified. No. In Arizona, a deed of trust is used to secure the lender's interest. To secure the lender's interest. So in Arizona, a deed of trust is used to secure the lender's interest. To convey title after a foreclosure sale? No. To secure the seller's interest in an agreement for sale? No. To secure the borrower's interest? No. A home is wired for 60 amp electrical service, but building code requires 100 amp. This is a form of functional obsolescence, right? So back in the day it was 60, nowadays it's 100, so it's functionally obsolete. So functional obsolescence. Functional obsolescence. Is it deterioration? No. Economic obsolescence? No. External obsolescence? No. The seller informs the listing agent that they are in bankruptcy, and the sale of the house must be approved by the bankruptcy court. The seller wants the agent to disclose the bankruptcy. The agent, Charlie, must inform the seller to disclose the bankruptcy because the sale of the house is contingent on court approval. The agent must inform the seller to disclose the bankruptcy because the sale of the house is contingent on court approval, right? So you always need to tell your seller to disclose pertinent information in order to close escrow. So the seller informs the listing agent that they are in bankruptcy, and the sale of the house must be approved by the bankruptcy court. So the seller doesn't want the agent to disclose the bankruptcy. So you still need to disclose it, right? Because it could come back to haunt you. The agent must inform the seller to disclose the bankruptcy because the sale of the house is contingent on court approval. A, must follow the seller's instructions. No, may only disclose the bankruptcy if the buyer asks. No, should refuse to question. Q grants R permanent permission to build a porch while encroaches on Q's property. R has received a easement. So R has received an easement. Fee simple, encroachment, adverse possession. No. Distributed ledger technology that uses a distributed, decentralized, shared and replaced ledger, and on which the data on the ledger is protected with the cryptography, is immutable and auditable. It provides uncensored truth, is a blockchain. So blockchain is an immutable and auditable, provides uncensored truth. Is it a transaction management platform? No. Smart contract? No. Secure website? No. A purchaser buys a lot from a subdivider prior to receiving the public report, which the following statement is incorrect. So the sale is revoked and the purchaser loses deposit. That's incorrect. Sale is revoked and the purchaser loses deposit. Incorrect. The sale is voidable by the purchaser. Yes. The purchaser can accept title without insurance of the public report. Yes. The purchaser can take legal action to void the sale within 3 years. Yes. V bought and occupied a home in Arizona. 2 months later, V borrowed $50,000 and gave the lender a note and has and trustee secured with the home. V defaulted on the loan, and the lender began a foreclosure action. The homestead exemption would have no effect on the foreclosure. Homestead exemption would have no effect on the foreclosure. Would have no effect on the foreclosure. Prevent the foreclosure? No. Allow V to collect the first $50,000? No. Give V an extra 90-day redemption period? No. If a rural subdivision lost the use of the fire department, it would suffer from economic obsolescence, right? So economic obsolescence, kind of like your environmental, right? We're talking about the fire department. Functional obsolescence, no. Physical regression. The decision in the case of State Bar of Arizona versus Arizona Land, Title, and Trust Company stated, Charlie, real estate brokerages were not legally able to write contracts. Real estate brokerages were not legally able to write contracts. Real estate brokerages were not legally able to write contracts. So the decision in the case of State Bar of Arizona versus Arizona Land and Trust Company stated real estate brokerages were not legally able to write contracts. Real estate licensees could prepare contracts. Yes. No. Real estate companies were liable if they failed to disclose. No. Since their companies had a long history of writing contracts, they were not practicing law without a license. A VA loan and receives a certificate of eligibility with full entitlement. What does this mean for the borrower? It means the buyer can get a loan from any VA lender. The buyer can get a loan from any VA lender. So a buyer qualifies for a VA loan and receives a certificate of eligibility with full entitlement. What does this mean for the borrower? It means the buyer can get a loan from any VA lender. The buyer can assume any VA loan only if the entire entitlement is used. No. The buyer is guaranteed up to $110,000 of entitlement, no matter what his income is. No. He can get a VA loan that is only up to 60% of the appraisal value. No. If a third party is involved in a transaction, what duties does the broker have to that party? Disclosure of any known defects. Disclosure of any known defects. So if a third party is involved in that transaction, what duties does the broker have to that party? So disclosure of any known defects. So it's kind of like you need to disclose any material facts anyways. You need to disclose any material facts or known defects. So no duties, no. The same fiduciary duties as the broker, no. Only disclosure of obvious defects, no. A seller is charged with $380 in prorated taxes on a closing statement because taxes become a lien on January 1st but are not yet payable. So when do they become a lien? January 1st, but are not yet payable. They become taxes because they become a lien on January 1st, but are not yet payable. So a seller is charged with $380 in prorated taxes on a closing statement because taxes, it is Charlie become a lien on January 1st, but are not yet payable. Ace has become due on January 1st, no. Are paid in advance, no. Become delinquent on January 1st, no. A buyer has a right to rescind in all of the following purchases except in Charlie improved lot in a subdivision if the buyer has received a public report. So that's except that one. So it doesn't include that one. So A, unimproved lot in a subdivision, the buyer is inspected, yes. Right? A buyer has a right to rescind, right? Cancel, rescind, or cancel in all the following purchases except so A, unimproved lot in a subdivision, the buyer is inspected, yes. Unimproved lot in a subdivision, the buyer has not inspected, yes. So has or has not inspected, they still have the right of rescission. Improved lot in an unincorporated area, not in a subdivision, yes. But the caveat for this one, improved lot in a subdivision if the buyer has received a public report. So again, the caveat if you haven't received the public report. Brokerage companies that are LLCs, Charlie, may be manager managed or member managed. Maybe manager managed or member managed, right? So if you have manager managed, means you don't have members. So your board of directors, they're going to manage the company. If you have member managed, well, you have all the members get to decide on everything, right? So you have votes, right? That's member managed. So brokerage companies that are LLCs, maybe manager managed or member managed. A says, are headed by officers and directors? No. May be formed by real estate salespersons as a licensed entity? No. Issue stock to their shareholders? No. The Arizona Residential Landlord and Tenant Act regulates Delta, 1 unit in a fourplex. 1 unit in a fourplex. So the Arizona Residential Landlord Tenant Act regulates 1 unit in a fourplex. So again, Arizona Residential Landlord and Tenant Act, they're going to regulate 1 unit in a fourplex. So you have a fourplex, right? You rent 1 out. You can rent all 4 out. You live in 1, rent 3 out, fourplex. And you have Landlord Tenant Act, right? So that's why Arizona Landlord Tenant Act regulate that. A, religious service housing? No. School dormitories? No. Public housing? No. Arizona Residential Landlord Tenant Act does not govern religious stuff, school dorms, public housing. You don't have. So if you go to ASU and you rent a dorm, does the Landlord and Tenant Act apply there? No. What about public housing? Does the Landlord and Tenant Act apply for public housing? No. But what about in a regular 1 unit in a fourplex? Yeah. Apartment buildings? Yes. A public report would be required on all of the following properties except what? Except commercial lots. Except commercial lots. So a public report would be required on all the following properties except commercial plots. So commercial lots, they're not required on public reports, not required for commercial lot. What about for residential timeshare? Public report is required. New home sales, public report is required. How about apartments converted to condos? Yes, public report is required. How about a commercial lot? No. The designated broker of an LLC must be Delta, a member, if the LLC is member managed. So you have an LLC, if it's member managed, what does that mean? That means that the company decisions are based on members, right? The members are voting. I have a nonprofit company called IMAV. We are not a member managed. We don't have members. We have board of directors, and we're managed by our board of directors' votes. We have members, but they're not voting members. So if you have a member managed, the designated broker of an LLC must be a part of the members managed. If a member is the LLC is member managed. So a DB, designated broker, if you have an LLC, that designated broker must be a what? Must be a member if the LLC is a member managed company. An associate broker for at least 1 year before becoming the designated broker? No. B, an officer and shareholder of the company? No. A non-member manager if the LLC is member managed? No. DB must be a member of the LLC is member managed. The statutes of frauds sets forth Delta the requirement that listings must be in writing to be enforceable. The requirement that listings must be in writing to be enforceable. That is what we call the statute of frauds, right? You know, verbal doesn't have a lot of weight, but if it's in writing, it has a lot of weight and it's enforceable by a judge. So judicial, foreclosure, judicial hearings, they can only be enforced by a judge if it's in writing. So that's the statute of frauds. Time period for a person to sue another? No. Penalties of a broker faces for taking an oral listing? No. Definition of fraud and misrepresentation? No. When evaluating a property for the purposes of taking a listing, which of the following should not be included? Delta, local places of worship. Local places of worship. So when evaluating a property for the purposes of taking a listing, which of the following should not be included? A local place of worship should not be included. Should the construction type? Yeah. The year built? Yes. The zoning and subdivision restrictions? Of course. The local places of worship? No. Don't include, what kind of churches are around the area. That should not be included. That's when you're evaluating a property for the purpose of taking a listing. The Mamas versus Oro Valley Townhouses case found that what? The Mamas versus Oro Valley Townhouse case found that Delta, misrepresentation can occur when a licensee discovers an error and remains silent. So you need to talk about it. You need to disclose it, right? So misrepresentation can occur when a licensee discovers an error and remains silent. So again, the Mamas versus Oro Valley Townhouse case found that misrepresentation can occur when a licensee discovers an error and remains silent. Unrepresented sellers have a duty to disclose material defects. No. Licensees have a duty to disclose defects the licensee could discover by a reasonable inspection of property. No. Material defects that do not affect the consideration need not be disclosed. No. An estate is terminated and will not revert to the grantor. The party who will receive the property is called the remainder man. Delta. Remainder man. So kind of in the name, remainder man. So remainder man is an estate is terminated and will not revert to the grantor. The party who will receive the property is called the remainder man. It's kind of like the leftover part. The party who's going to receive the property is going to be the remainder man. So is it A, revisionary man? No. Severalty man? No. C, real estate instructor? No. A person who solicits reservations for residential dwellings must be licensed if the occupancy will be greater than 31 days. 31 days. So again, a person who solicits reservations for residential dwellings must be licensed if the occupancy will be greater than 31 days. So 10, 14, 30, no, 31 days. So again, a person who solicits reservations for residential dwellings must be licensed if the occupancy will be greater than 31 days. Which of the following statements is true? Delta, the longer the loan, the lower the total monthly payment. Right? The longer the loan, the lower the total monthly payment. The longer the loan, the lower the total monthly payment. So again, which of the following statement is true? The longer the loan, the lower the total monthly payment. So that's why typically some people if you did a 15-year mortgage, right, you have bigger payments, right? If you have a 30-year, you have lower payments, right? Because you have more time to stretch out the payments. So A says the longer the loan, the higher the total principal paid. No. The longer the loan, the lower the total amount of principal paid. No. The longer the loan, the lower the total amount of interest paid. No. Which of the following complaints against a licensee would the Arizona Department of Real Estate investigate? It's going to be Delta. Trust account complaints. Trust account complaints. So trust account complaints. So which of the following complaints against a licensee would the Arizona Department of Real Estate investigate? Is trust account complaints. So ADRE, right? If you are doing property management, you're a broker and you have a trust and you have a trust account complaint, who's going to investigate that? Arizona Department of Real Estate, mainly the commissioner, because they investigate those trust account complaints. Would it be landlord-tenant disputes? No. Homeowner association disputes? No. Ethics complaints? No. Which way of terminating an agency may give the principal the right to sue the broker for damages? It is rescission by the broker. Rescission by the broker. So which way of terminating an agency may give the principal the right to sue the broker for damages? It's when the broker rescinds their offer. Rescission by the broker. Conditional release? No. Unconditional release? No. Performance? No. It's rescission by the broker. Which of the following services could a licensee who is representing a buyer provide to the buyer when negotiating to buy a property listed by another licensee working in a branch office of the same brokerage firm? This is Delta. Obtaining a disclosure statement from the seller regarding structural defects. Obtaining a disclosure statement from the seller regarding structural defects. Obtaining a disclosure statement from the seller regarding structural defects. So again, which of the following services could a licensee who is representing a buyer provide to the buyer when negotiating to buy a property listed by another licensee working in a branch office of the same brokerage firm. They can obtain a disclosure statement from the seller regarding structural defects. I says advising the buyer about initial offering price, no. Assisting the buyer in negotiating terms which are detrimental to the seller, no. Informing the buyer that the seller would accept a price lower than the list price, no. The statutes of frauds sets forth the requirement that to be enforceable, a deed must be in writing. So delta, in writing. In writing. So the statutes of frauds sets forth the requirement that to be enforceable, a deed must be in writing. So a deed must be recorded? No. Notarized? No. Prepared on a standard form? No. In writing. A retail business sees a sharp decline in their profits due to a newly constructed freeway on-ramp that bypasses the property. This is an example of incurable external obsolescence. Incurable external obsolescence. Incurable external obsolescence. So again, a retail business, they see a sharp decline in their profits due to a newly constructed freeway on a ramp that bypasses the property. This is an example of incurable external obsolescence. So, the business can't really do anything about it because it's an external, right? It's not inside the business that's affecting their business. It's external, and it's called obsolescence, obsolete, right? Incurable. They can't do anything about it, right? It's environmental impact, so external obsolescence. So is it a curable economic obsolescence? No. Curable property deterioration? No. Incurable functional obsolescence? No. The amount of cash that a buyer must bring to closing will appear on the settlement statement as the buyer charges minus the buyer's credits. The buyer's charges minus the buyer's credits. The buyer's charges minus the buyer's credits. So again, the amount of cash that a buyer must bring to closing will appear on the settlement statement as the buyer's charges minus the buyer's credits. So will it be the total of charges to the buyer? No. The seller's credits minus the seller's charges? No. The purchase price minus earnest money? No. Which might be a misrepresentation in an ad? So this is Delta, providing a school district map that is incorrect. Providing a school district map that is incorrect. Providing a school district map that is incorrect. So that's a misrepresentation in an ad. When you provide a school district map that is incorrect, that's a misrepresentation in an ad. Stating incorrect zoning that allows the same use as the actual zoning. No. Overstate the square footage of a house by 1%. No. It's not misrepresentation in that. Using the term approximately when referring to acreage. No. In Arizona, an unaccepted offer to purchase must be kept for 1 year from the Date of rejection. Date of rejection. Date of rejection. So in Arizona, an unaccepted offer to purchase must be kept for 1 year from the date of rejection. So typically, rejected offers are kept for 1 year. Accepted offers under contract that close escrow, you keep it for 5 years. Rejected offers for 1 year from the date of rejection. Date of the offer, no. Signing of the listing, no. Termination of the listing agreement, no. The central air conditioning unit breaks down in an apartment building during a heat wave. According to the Residential Landlord-Tenant Act, tenants may immediately, Charlie, give the landlord a 5-day notice to repair it. Give the landlord a 5-day notice to repair it. Give the landlord a 5-day notice to repair it. So again, the central air conditioning unit breaks down in an apartment building during a heat wave. According to the Residential Landlord-Tenant Act, the tenants may immediately give the landlord a 5-day notice to repair. So this happened to me before in the past. I'm renting out rooms in a house, and tenants call me up and they say, hey, AC unit went down. What do I do? Right, next day, I go buy some AC units, I install them, right? Landlord has 5 days to fix the problem. So A, rent window, air conditioners, and deduct the cost from their rent? No. Refuse to pay rent until the unit's repaired? No. Abandon the premises immediately? No. A home is wired for 60 amp electrical service, but the building code requires 100 amp service. This is a form of functional obsolescence. Functional obsolescence. Functional obsolescence. So it's functionally obsolete because, back in the days, it was 60 amps electrical. That was the code. Nowadays, it's now 100 amp, right? So it's functionally obsolete. So is this deterioration? No. Economic obsolescence? No. External obsolescence? No. An estoppel certificate is normally used when a Charlie loan is assigned. Loan is assigned. Loan is assigned. So again, an estoppel certificate is normally used when a loan is assigned. When a loan must be stopped, no. Property sold, no. Loan is assumed, no. If a third party is involved in a transaction, what duties does the broker have to that third party? So, disclosure to any known defects. A home sells for $405,000, but was listed for $435,000, and the buyers are getting 90% loan. The sellers are paying a 6% commission, and the buyers want the sellers to pay two discount points. The sellers are paying for a $55 recording fee, $1,700 in closing costs, and $200 for title insurance. The sellers originally purchased their home for $250,000. Their loan balance is $183,000, while the seller's proceeds for the sale. So here you're going to do some math on this one. Is probably brokerage companies that are LLCs. Charlie may be manager managed or member managed. Maybe manager managed or member managed. Maybe manager managed or member managed. So broker companies that are LLCs may be manager managed or member managed. Are headed by officers and directors? No. May be formed by real estate salespersons as a licensed entity? No. Issue stock to their shareholders? No. Which is the first step in the foreclosure of a tax lien? Charlie, notice is sent to the property owner. Notice is sent to the property owner. Notice is sent to the property owner. So the first step in the foreclosure of a tax lien is when you give notice to the property owner. Notice sent to the mortgagee? No. All parties must be notified? No. Treasurer must be notified? No. A public report would be required on all the following properties except, in order to obtain a prescriptive easement, there must be adverse use. Adverse use. Adverse use. So in order to obtain a prescriptive easement, there must be adverse use. Permission from the owner? No. Interrupted use? No. Dominant and serving owners? No. The decision in the case of State Bar of Arizona versus Arizona Land Title and Trust Company stated, Charlie, real estate brokerages were not legally able to write contracts. Real estate brokerages were not legally able to write contracts. Real estate brokerages were not legally able to write contracts. So the decision in this case of the State Bar of Arizona versus Arizona Land Title and Trust Company stated real estate brokerages were not legally able to write contracts. A, real estate licensees could prepare contracts. No. Real estate companies were liable if they failed to disclose material facts. No. Since the companies had a long history of writing contracts, they were not practicing law without a license. No. In advertising real estate, Bravo, an inactive licensee who markets her own house for sale must include the words owner agent in any ad. So an inactive licensee who markets her own house for sale must include the words owner agent in any ad. So in advertising real estate, an inactive licensee who markets her own house for sale must include the words owner agent in any ad. The designated broker must supervise all ads with no exceptions. No. The term acre could apply to either a full acre or commercial acre. No. The commissioner's rules do not apply to commercial property for lease. No. A purchase agreement uses a standard clause that states this contract cannot be altered, amended, changed, modified, revised, or terminated without written specific consent of both the buyer and the seller. To make a change to this purchase agreement, Alpha, the buyer and seller can communicate the changes via email. The buyer and seller can communicate the changes via email. The buyer and seller can communicate the changes via email. So a purchase agreement uses a standard clause that states this contract cannot be altered, amended, changed, modified, revised, or terminated without written specific consent of both the buyer and seller. To make a change, this purchase agreement where the buyer and seller can communicate the change via email. So via email, because it's in writing, the buyer and seller can agree to change over the phone. No, that'd be verbal. One party can make it. No, they need both parties. A facsimile transmission of the amendment from one party is acceptable. No. The case is Kelo versus New London, and Bailey versus City of Mesa dealt with eminent domain. Eminent domain. Eminent domain. So the cases Kelo versus New London and Bailey versus City of Mesa, they dealt with eminent domain. Did they deal with taxation? No. Police power? No. Escheat? No. A clause that allows lenders to take over collection of rents when a borrower is in default is a bravo assignment of rents clause. Assignment of rents clause. Assignment of rents clause. So a clause that allows lender to take over collection of rents when a borrower is in default is a assignment of rent clause. Is it a cross collateralization clause? No. Subordination clause? No. Non-recourse clause? No. Which of the following protects the lender in the event of a foreclosure? So it is mortgage insurance. Mortgage insurance. So mortgage insurance. So sometimes it's called PMI, private mortgage insurance. That's going to protect the lender in the event of a foreclosure. So title insurance, no. Homeowners insurance, no. Mortgage life insurance, no. In the case of Verma versus Stir, the court decided that failure of the seller to give the buyer an affidavit of closure, bravo, allows the buyer to cancel the purchase prior to closing. Allows the buyer to cancel the purchase prior to closing. Allows the buyer to cancel the purchase prior to closing. So in the case of Verma versus Stir, the court decided that failure of the seller to give the buyer an affidavit of disclosure allows the buyer to cancel the purchase prior to closing. So when you when you're selling property, you need to give the buyer an affidavit of disclosure, otherwise they can cancel before you close. Allows the buyer to cancel the purchase? No. Is not required? No. Is required only if the property is completely outside of subdivision? No. A piece of property sells for $125 an acre, and the sales price is $185,000. What is the size of the property? So you need to do some math. It's 1,480 acres. 1,480 acres or 1,400 acres. A document recorded to give notice of an optionee's rights and usually does not include the terms of the option is a memorandum of option. Memorandum of option. Memorandum of option. So a document recorded to give notice of an optionee's rights and usually does not include the terms of the option is called a memorandum of option. Is it a rolling option? No. Lease option? No. Right of first refusal? No. In a purchase contract, a buyer has 45 days to conduct environmental research on a property. This is referred to as due diligence. Due diligence. Due diligence. So in a purchase contract, the buyer has 45 days to conduct environmental research on a property. This is referred to as due diligence. Due diligence is typically, your home inspection. You have like 10 days to do a home inspection. But if it's environmental, commercial property, you have 45 days to do environmental. But that's called due diligence. You're doing your due diligence to make sure the property is what you want it to be. Is it called times of the essence? No. Title research? No. Disclosure? No. Long-term capital gain treatment applies if the property has been held more than 12 months. 12 months. 12 months. So long-term capital gains greater than 12 months. Short-term capital gains is less than 12 months. So long-term capital gain treatment applies if the property has been held more than 12 months. So 6 months, no. 18, 24, no. An active management area is an area in which excess overdraft is occurring. Excess overdraft is occurring. Excess overdraft is occurring. So an active management area is an area in which excess overdraft is occurring. Excess irrigation is occurring, no. Surface water is actively managed, no. No new wells can be drilled, no.